Hello everyone and welcome to this third video tutorial on contract terms. Today we're going to be looking at exclusion clauses. An exclusion clause is a term in a contract which seeks to exclude or limit the liability of one of its parties. For example, it may state that a party has no liability if the contract is breached, or alternatively seek to limit the range of remedies available or the time in which they can be claimed. I thought it might be useful as a bit of an introduction just to contextualise this a bit for you. This is actually a picture of one of my pet insurance policies, and I've put a big red box around part of this contract, which is an exclusion clause. And I'm just trying to illustrate really just how common exclusion clauses are, that you will have probably come across lots of them throughout your life. Pet insurance policies are notorious for exclusion clauses. So we have a little look at this. I know it's small, but basically it's telling you what they're not able to cover under their insurance policies. So they are excluding a waiting period. So it's telling me that they're not going to pay out for a claim for any accident that occurs within the first 48 hours, that they won't pay if my pet passes away in the first 14 days, that they won't pay for any vet's fees within the first 14 days. So they are excluding their liability for those things. You can see on other parts of this page actually that they also exclude liability for pre-existing conditions, so any health problem the animal had before you took out the policy. And you can see that they've also got limitation clauses here, so that they're saying the most that they're going to pay is $7,000 a year, the most that they'll pay for complementary treatments is £1,000, and the most that they'll pay for food prescribed by a vet is £200 a year. So an exclusion clause here is where they won't cover it at all. This is a limitation clause where they are limiting how much money you can claim. Another example here, this was actually an insurance policy I took out for a holiday, and you can see here I've highlighted exclusion clauses here, and it says what you are not covered for. So they are telling you what they are excluding from their liability. So I just wanted to show you really as an introduction how common they are, and it might be a really useful activity to dig out some contracts of yours or your parents and have a look and see if you can find any exclusion clauses. As we've said, an exclusion clause definition for you here is when one party to the contract attempts to exclude all liability or to limit liability for breaches of the contract. And you can imagine here that exclusion clauses can be seen as being quite unfair potentially on a person, particularly if exclusion clauses are written in very small print, if they're hidden away in a long document, if they're written in language which is difficult for people to understand. So because exclusion clauses have the potential to be very unfair, the law has tried to control the use of these clauses by the common law and by statute. To regulate exclusion clauses, we have common law controls where the court will look at whether the exclusion clause has been validly incorporated. That means, has it been made part of the contract properly? And the other type of control is a statutory control. So it might be that, okay, it has been incorporated into the contract, but a statute or an act of parliament might declare that the clause is invalid because it's unfair. And we'll look at the Unfair Contract Terms Act and the Consumer Rights Act on that. So we're going to start off by looking at common law controls, how we incorporate an exclusion clause into a contract. This way that an exclusion clause will be incorporated into a contract is by signature. And this comes from a case called Lestrange and Graucob. And this gave us a very important rule in contract law that if a claimant signs a contract which contains an exclusion clause, he's bound by its terms. And that's even if they didn't read the document and even if they didn't understand the document. So when I signed my pet insurance policy that I showed you at the beginning, I was very careful to make sure that I read all the small print, I read all the exclusion clauses, because once you've popped your signature on there, in general, you are going to be bound by its terms. Sometimes, however, a contract will be formed where there wasn't a signature wasn't needed, but there is a contract there. And it is possible to exclude liability by reasonable notice. And this comes from the case of Parker. And you can see it's an old case here from 1877. And in this case, a cloakroom ticket had details of cloakroom opening hours and also the words "see back." And on the back of this ticket was a limitation clause, which said that if you gave your coat in to this cloakroom and they happened to lose your coat, the most that the company would pay you back was £10 for the loss of the property left with them. That's quite a large amount of money, though, in 1877. So the claimant gave his coat in to this cloakroom and they lost his coat and his bag, and he was trying to claim £24. His claim failed, and what the court said was, although he hadn't signed anything, their clause, their exclusion clause, liability only for £10, had been incorporated into the contract by reasonable notice. And I think they were influenced in this case on the fact that the ticket said "see back" on it. So it was trying to draw his attention to that clause. And also the ticket was quite an important document because you had to keep hold of the ticket in order to claim your property back. So he'd had reasonable notice, so it had been incorporated. In the case of Ollie and Marlborough, our claimant arrived at a hotel and he paid for his hotel room. And then when he went into his hotel bedroom, there was a notice on the back of the bedroom door with an exclusion clause on it. And it was held that that exclusion clause was not incorporated, it was not part of the contract, and it was therefore not binding on him, because the court said that any exclusion clause should be given before or at the time the contract was made. So it should have been given to him here in reception when he was paying for his room, not when he was already in there, because by that point he'd already signed up. So it's unfair to make it binding on him at that point. Chapelton and Barry is a really useful case for comparing to the case of Parker, because on the face of it, it looks like the facts are quite similar. Now, in this case, you can see that exclusion clauses were printed on the back of a ticket that was given in return for the purchase of a deck chair on a beach. So people were renting deck chairs to take onto the beach. And this ticket had a clause on the back, but it was deemed that this ticket was more like a receipt, and a person wouldn't expect it to contain contractual terms. And the principle from this case is that notice of exclusion clauses should be in a document that the claimant would reasonably expect to contain contractual terms. And the court was saying, if this is just like seen as a receipt, it's not seen as important, the person isn't going to be looking at it, so it's not fair for that clause to be incorporated. That's different from Parker, where there was a clause on the back of a ticket, because in Parker, the ticket was not seen as being like a receipt. The ticket was seen as being quite an important document because you needed that ticket to claim your property back. And also in Parker, the ticket said "see back," whereas in this case, there was no such warning on the ticket. So I think what this case is showing is that you've got to look quite closely at the individual facts in your case or your scenario to determine, is it reasonable to expect an exclusion clause to be on that document? Has it been drawn to their attention before or at the time that the contract was entered into? The way that an exclusion clause can be incorporated is through a previous course of dealings. So if the parties have dealt with each other before, then the term may be incorporated through these dealings, even where the term was not brought to the attention of the other party on this particular occasion. And that's because you would expect the other party to already be aware of that term. So this is illustrated in the case of Sperling and Bradshaw. And in this case, the parties have been doing business together for several years. And just on this one particular occasion, the documentation containing the exemption or the exclusion clause hadn't been given prior to the dealing. Now, what the court said was, although reasonable notice had not been given on this occasion, because they've been doing business together for several years, the parties had enough dealings in the past to warrant the clause incorporated on this occasion. So again, you've got to look out for that. Have they dealt with each other before? Do they already know what the situation is, what the terms are? What we've looked at so far are the common law controls on exclusion clauses. So under the common law, we have to have the clause incorporated, and that can be through signature, through notice, and through previous course of dealings. What we're going to look at now is, okay, if it has been incorporated, can we possibly make that clause invalid using Acts of Parliament? The first act we're going to look at here is the Unfair Contract Terms Act 1977. Really important to recognise that this is only for business-to-business contracts, which I abbreviate to B2B. So it doesn't apply business to consumer. This is only in situations where you've got one business contracting with another business. So for example, Liam has a heating business, and sometimes he gets his boilers from a manufacturer called Worcester Bosch, and they're also a business. So when he buys boilers from Worcester Bosch, that's business to business. It's one business to another. So these rules apply to those contracts. They don't apply to if a business sells to a consumer. I've included on this slide some of the key provisions from the Unfair Contract Terms Act. So Section 2.1 says that a business can't exclude or restrict liability for death or personal injury resulting from negligence. Section 6 says that they can't exclude anything that's implied by statute. Section 11 says that all the terms must be subject to a reasonable test. And Schedule 2 gives some factors that we should take into account when we're applying the reasonableness test. The type of contract that you'll be more familiar with, though, is a B2C contract, which is business to consumer. So if a shoe shop sells you shoes, that's a B2C contract. And in that situation, we don't use UCTA, the Unfair Contract Terms Act, we use the Consumer Rights Act 2015. And we've already looked at this act a little bit when we were looking at implied terms. Again, I've included some key points from the Consumer Rights Act in terms of exclusion clauses here. So Section 62 says that all consumer contract terms and notices must be fair. And the section gives a grey list of unfair terms. And it also says that terms should be transparent and prominent. So if a business is trying to include an exclusion clause, that clause should be highlighted, made clear to the consumer. And if you think back to the examples I showed you at the start of my pet insurance policy, they quite clearly said things like what we are not able to cover. And they're drawn to the attention of the consumer. If there's anything unusual or harsh in the contract, that should be extra prominent for it to be valid. Section 65 says that you can't restrict liability for death or serious injury resulting from negligence. To summarise on exclusion clauses then, what we've seen is that there are some common law controls where the exclusion clause must be incorporated into the contract, and that can be by signature, by notice, or by previous dealings. And then there is some statutory control of exclusion clauses. So if they have been validly incorporated, if it's a B2B contract, UCTA applies. And if it's a B2C contract, the Consumer Rights Act applies. And it's really important for this topic that you try to learn some of those key sections for each of those acts and make sure that you are clear in the differences between B2B and B2C.